p.m. on May 30th, 2021, officers Nicholas Hanning and Ellie Summers of the Idaho Springs Police Department in Idaho Springs, Colorado, responded to a 911 call from Timothy Braden and his roommate Brittany Odom, who had just moved into a new apartment building, alleging that their new neighbor, 75-year-old Michael Clark, had punched Ms. Odom in the face after a noise dispute. The officers arrived at the apartment building and knocked on Mr. Braden and Ms. Odom's door.
No. Hey, I'm Tim. This is Brittany. That was the neighbor right there. We're the ones that called. Wait. This is Brittany. She's the one that got hit. I live here. This is my friend Brittany. And then this is my neighbor that hit her. I wasn't even here. I was outside. I literally just saw
He banged on the door, or through the wall. Bam, 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 and I'm sleeping. Shut the up. And so I came out and was like, what's going on? He busted all of my shit. My nose, my mouth.
Okay.
All I want to do is hey, what was disturbing you? And he was like, shut the fuck up. Boom.
Was he white, black, Hispanic?
He's white.
Does he have hair?
Yeah.
Is he bald?
Gray hair?
Yeah, gray hair. He's an older guy. He's about this tall.
Okay.
That guy lives right there in that room. And that's where the wall would have gone.
He was bang, bang, bang. That's what woke me up.
We just moved in here yesterday, but I saw him last night or night before.
Okay.
After briefly talking with Ms. Odom, the officers walk away and knock on Mr. Clark's door. Ms. Odom was obviously intoxicated throughout her conversation with officers, and there was absolutely no evidence of the various injuries she described receiving. Additionally, had the officers requested that dispatch check her background, they would have discovered that Ms. Odom had a substantial criminal record, including a 2016 conviction of fraud in the first degree for giving a false identity to police officers, multiple felony domestic violence charges, and a conviction for DUI .15 BAC causing property damage. As we have discussed before on ATA, under the so-called knock and talk doctrine, officers are typically authorized to knock on someone's door and ask questions without a warrant, probable cause, or reasonable suspicion. The Supreme Court explained this doctrine in the 2013 case of Florida versus Jardine, stating that, quote, "We have recognized that the knocker on the front door is treated as an invitation or license to attempt an entry. This implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave." Accordingly, the court concluded that, quote, "A police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do." However, while a court would almost certainly conclude that the officers could knock on Mr. Clark's door in an attempt to warrant may approach a home absent invitation to the Supreme Court explained that, as we have discussed before on ATA, under the While a court would almost certainly conclude that the officers could knock on Mr. Clark's door in an attempt to speak with him, it is far less likely that a court would determine that they had probable cause to arrest him. In the 2007 case of Cortez versus McCauley, the 10th Circuit Court of Appeals, which has jurisdiction over Colorado, explained that, quote, "A warrantless arrest is permissible when an officer has probable cause to believe that a person committed a crime. Probable cause to arrest exists only when the facts and circumstances within the officer's knowledge, and of which they have reasonably trustworthy information, are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed." The court then clarified that, quote, "In evaluating whether the events leading up to this arrest amount to probable cause, we ask whether an objectively reasonable officer could conclude that the historical facts at the time of the arrest amount to probable cause. Probable cause is based on the totality of the circumstances and requires reasonably trustworthy information that would lead a reasonable officer to believe that a person about to be arrested has committed or is about to commit a crime." Likewise, the court indicated that, quote, "A police officer may not close her or his eyes to facts that would help clarify the circumstances of an arrest. Reasonable avenues of investigation must be pursued, especially when it is unclear whether a crime had even taken place." Here, because, given her level of inebriation, Ms. Odom was an unreliable witness at best, there was no physical evidence indicating that she had been attacked, and she had a criminal history involving intoxication, violence, and lying to the police, a court would likely conclude that a reasonable officer would not believe that they had probable cause to arrest Mr. Clark based solely on Ms. Odom's uncorroborated accusation.
I'm gonna put my dog in the bathroom, okay?
Okay.
What do you want? What the? Put it down!
Put it down!
Put it down!
Get on the ground now!
Back up. Get out here right now! Get out here!
Get on the ground!
No. They hit that wall so hard, I thought they were going to come through the wall.
When the officers knock on Mr. Clark's door without identifying themselves as the police, Mr. Clark answers the door holding a collectible sawfish snout sword, which is made from the bill of a sawfish. In a later statement, he explained that he thought it was his neighbor's, and he grabbed the sword in case he needed to protect himself. When Mr. Clark opens the door, Officer Hanning steps into the apartment, appears to shove Mr. Clark, and orders him to put down the sword. Mr. Clark immediately complies, returning the sword to the top of a bookshelf. However, when Officer Hanning orders Mr. Clark to step out of the apartment, while Officer Summers simultaneously orders him to lie down, Mr. Clark refuses to do either, and Officer Hanning immediately fires his taser without warning. When he is hit by the taser, Mr. Clark falls to the ground, hits his head on a dining chair, and loses consciousness. Before we can discuss the legality of Officer Hanning's taser usage, it is important to note that Colorado law does not prohibit an individual from openly carrying a sword of any length in both public and private locations. Additionally, while Section 18-12-105 of the Colorado Revised Statutes makes it illegal to conceal carry a sword with a blade length exceeding 3.5 inches, the statute specifically states that, quote, "It shall not be an offense if the defendant was in his own dwelling at the time of the act of carrying." So Mr. Clark was inarguably within his rights to answer the door while carrying the sword. Under Idaho Springs Police Department Policy Number 304, quote, "The taser device is intended to control a violent or potentially violent individual, while minimizing the risk of serious injury. The taser device may be used in any of the following circumstances, when the circumstances perceived by the officer at the time indicate that such application is reasonably necessary to control a person. The subject is violent or is physically resisting. The subject has demonstrated by words or action an intention to be violent or to physically resist, and reasonably appears to present the potential to harm officers, himself, or others. Likewise, the taser policy specifies that the use of the taser device on certain individuals, including elderly individuals and obvious juveniles, quote, should generally be avoided unless the totality of the circumstances indicates that other available options reasonably appear ineffective or would present a greater danger to the officer, the subject, or others, and the officer reasonably believes that the need to control the individual outweighs the risk of using the device. The policy also requires that, quote, a verbal warning of the intended use of the taser device should precede its application unless it would otherwise endanger the safety of officers or when it is not practicable due to the circumstances. Or, the quote continues, if, after a verbal warning, an individual is unwilling to voluntarily comply with the officer's lawful orders and it appears both reasonable and feasible under the circumstances. According to Section 18-1-707 of the Colorado Revised Statutes, quote, peace officers in carrying out their duties shall apply non-violent means when possible before resorting to the use of physical force. A peace officer may use physical force only if non-violent means would be ineffective in effecting an arrest, preventing an escape, or preventing an imminent threat of injury to the peace officer or another person. Likewise, Section 18-8-803 of the Revised Statute states that, quote, a peace officer who uses excessive force in pursuance of such officer's law enforcement duties shall be subject to the criminal laws of this state to the same degree as any other citizen. Here, Officer Hanning's decision to fire his taser in this situation was in clear violation of multiple facets of this policy, as Mr. Clark was an elderly individual who was not violent and in no way had indicated he intended to harm anyone. He simply verbally refused to comply with conflicting orders from the officers while standing in a neutral position in his own home, and then Officer Hanning deployed his taser without the required warning. The court would likely also conclude that it constituted excessive force under Colorado law, as Mr. Clark was not under arrest at the time the taser was fired, and there was no evidence that he was attempting to escape or injure anyone. And even if there was, Mr. Clark had given no indication that non-violent means would be insufficient for the officers to arrest him or prevent escape.
Party's unconscious.
Sir? 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 Sir, talk to us. Talk to me. Talk to me. Sir, talk to me.
That big bat that he's holding, that looks like a freaking...
Where did you find that? Did you have to hunt for it?
It was laying right there on the ground when I walked in. Alright.
I did not get that down.
Not arguing with you.
I did not get that down.
Alright. We're gonna sit up.
I did not get that down.
I'm gonna go down with you.
It was on.
You want him out of
top
cuffs
up there.
up here? Okay.
Did you go in my apartment and look for weapons?
Mr. Clark, you're gonna sit up.
Did you look at my apartment and look for weapons?
We don't need, they don't need to look at the apartment. It was here in the hallway.
How did they get in the hallway?
After Mr. Clark loses consciousness, the officers do not call for medical assistance. Instead, they drag his unconscious body into the hallway. Then, after requesting EMTs on the scene, Officer Hanning retrieves Mr. Clark's sword from the top of the bookshelf in his apartment and drops it in the hallway. Although they never explicitly admit this, the officers appear to be staging a crime scene to make it seem like Mr. Clark was attacking them with the sword when the taser was deployed. According to Section 18-8-610, quote, "A person commits tampering with physical evidence if, believing that an official proceeding is pending or about to be instituted, and acting without legal right or authority, he knowingly makes, presents, or offers any false or altered physical evidence with intent that it be introduced in the pending or prospective official proceeding." While there is limited case law interpreting this statute, it is clear that the officers moved Mr. Clark and the sword in an attempt to make him appear to be a violent threat, knowing that an investigation of his use of force was likely to ensue, and that Officer Hanning could be criminally charged for using excessive force. Therefore, it is certainly possible that the officers could be convicted of tampering with evidence under this statute.
What is going on? I have done nothing wrong. What did I do?
What's that?
What did I do?
You punched that girl.
Huh?
Punched that girl and then answered the door with a freaking machete, man.
Oh, no, that is so absolutely false.
Alright.
Okay.
We're gonna stand you up.
I did not come after nobody.
Okay. You're dealing with me now. We're gonna go down to the ambulance so I can...
I was just in bed.
Alright, we're gonna stand up on the count of 3. Ready? 1, 2, 3, stand up.
I attacked nobody. I did nothing.
Sit
Does this
back.
look familiar?
I messed up on top there.
Just sit.
I did not come at anybody.
Sit down.
Swing your legs up. Swing your legs up. Sir, swing your legs up. Alright, feet please. Go into restraints.
Okay.
Mr. Clark was immediately taken to a hospital, and despite the officer's threats, he was never criminally charged. A toxicology screen was completed, and no alcohol or illegal drugs were found in his system. On June 1st, 2021, 2 days after he was tased, Mr. Clark suffered a stroke while still in the hospital, and as of the date of this episode, he is still unable to care for himself and requires 24-hour supervision and care. In July 2021, Officer Hanning was charged with assault in the 3rd degree against an at-risk person, a Class 6 felony offense, and was terminated from his position at the Idaho Springs Police Department. He pleaded guilty to the charge in January of 2022 and was sentenced to 2 years of probation, 120 days of electronic home monitoring, and 150 hours of community service. He was not charged with any offenses surrounding the apparent cover-up attempt after he tasered Mr. Clark. Officer Summers resigned from her position at the Idaho Springs Police Department in October 2021, but she was not charged with any crimes. In July 2021, Mr. Clark filed a federal lawsuit against the Idaho Springs Police Department, and on November 2nd, 2022, Mr. Clark's attorney announced that the lawsuit had settled for $7 million. However, the city maintained that the settlement was not an admission of liability and that it settled for, quote, economic reasons and to bring closure to all involved. Overall,